For more on this, we're now joined by a lecturer at Nelson Mandela University in the Eastern Cape and political analyst Ongama Mtimka. Thanks so much indeed for joining us, and welcome to the program.
Good evening to you and your viewers, Peter. Thank you for having me.
What do you make of this move to refer this matter to a panel of experts? Are we seeing a party rallying behind its president, or is this the normal course of dealing with issues?
I think that the Constitution is very clear that when there has been an act that is a serious violation of the Constitution, there needs to be, there can be an action, a removal of the president from office with a 2/3 majority. However, we have seen that when events happen and there are, there's prima facie example of such a violation of a constitution, that sometimes the thrashing out of claims and counterclaims is important to arrive at a widely accepted, account of events, a designation that in fact, indeed, there has been a serious act of misconduct before Parliament can, act on a matter. And the reason why that is the case is because when you've had a rigorous process of determining the true extent of the seriousness of a matter, you then are able to create a predictable outcome from the process. And I think that a few things are at play here, Peter. One, remember that the ANC is the majority party in Parliament, and therefore the Speaker could act in a partisan way. However, the benefit of operating in an environment where it's rules-based is that once there's compliance with the rules, then there is no legal room for the presiding officer to stand on in granting an answer that may not be consistent with what the rules prescribe. So in this sense, then, I think this is consistent with the rules, and she has taken an action which is in fact in tandem with the rules. So that's important to note, rather than the power-centric approach that majority parties tend to use, especially in our continent and in fact the ANC. It's a departure from the behavior that you saw when National Assembly saw that they were confronted in the Zuma time, for example, with a president, an executive that was behaving in a delinquent manner, and Parliament needed to take action, and Parliament was actually sticking its head in the sand and defending the president. So one may argue that there's a slight deflection here, but my view is that by acceding to the request of the ATM in line with the rules, the Speaker has chosen the more rules-based, more sound rules-based engagement, rather than the power-centric approach that tends to be used by the ANC.
All right, so help us understand. I mean, this is a police case. The police are investigating. Aren't they the proper authority to adjudicate whether a crime has been committed? And then if it is established that there is a criminal case, the president is charged, then Parliament steps in and say, given what we've heard from the authorities, we need to take some action.
That's a very interesting one. I've always been of the view that politicians are able to determine, are able to act in a way that's not necessary, that may not be contrary to the law, but in fact may be in tandem with the law. So, for example, on the basis of the scandal the president is facing, it may very well be that Parliament deems the allegations to be serious enough that the president is implicated in acts of misconduct, and may act if they are able to secure the 2/3 majority sooner than any other legal process. The idea that a parliamentary process must await judicial processes doesn't always, bode well for the integrity of our system. Remember, that's the same thing that the ANC has done. When its constitution says you've got the acts of misconduct include ethical questions and moral questions, only for them to prescribe that people who should be forced to step aside are only those who are charged. Now that takes the right of a political party to deal with questions of ethics and traps it in judicial processes. And then what you do by doing that, you increase the risk of capture of judicial processes, because you've created a situation where politicians cannot act on the basis of what they may know to be, general acts of misconduct in terms of morality and ethics, and you make it a judicial or legal or criminal issue. So my view is that Parliament is empowered enough to undertake this route. However, Peter, what would be wrong is for a parliamentary committee to arrive at a finding that may be contrary, for example, to a finding of the public protector or a finding of the courts in South Africa. That's what would be wrong. That's what would be wrong, as it happened, for example, with Parliament, say, noting the report of the public protector with respect to Nkandla, but, undertaking its own process. You know what I mean? So,
yes.
so if Parliament, there isn't a report yet of the public protector or a report from the courts, Parliament is very much well empowered to undertake its own investigation and determine the extent to which what the president is accused of is serious, and actually take a political decision based on that. And obviously, if the report of the public protector or any process that's currently underway is on the positive, then it vindicates whatever position would have been taken. If it's not, then the president would have whatever recourse that would be available to them in order to challenge the parliamentary process.
All right. What that suggests then is the burden of proof is much lower in Parliament, because they're dealing with ethics and other nuances that may be problematic. So even before a criminal process is completed, the political arm could remove him as president with less proof put on the table.
Should it be proved? Should the whoever is the committee are going to deem that the matter is serious enough, or the president is implicated serious enough? Now, obviously, the extent to which remember the courts are the final arbiters of disputes. So Parliament would have to undertake this process, mindful that if it were to be challenged, and the right of Parliament and Parliament would be challenged on the basis beyond questions of ethics and morality, as to how it arrived at its decision, then obviously the courts become the final arbiters of disputes. However, it doesn't necessarily follow that because there hasn't been a judicial process, that Parliament cannot undertake its own investigation and make its own determination about the seriousness of a matter. As long as politicians acting within that space understood that theirs would always be subject to a judicial review.
All right, Ongama, we're going to have to leave it there. We live in interesting times, to say the least. Thanks so much for your time. Your insights are always greatly appreciated.